Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help widget below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please email it to Haley Musgrave at hmusgrave@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. Please note, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. Enter the 5-digit code that will be announced during the presentation on the form and return the form to Haley Musgrave at hmusgrave@foley.com immediately following the program. And now I would like to turn the presentation over to John.
Thanks, Haley, and thank you all for attending our presentation today on the 2016 Proxy Season Preview. I'm John Wilson, a partner at Foley & Lardner in our Transactional Securities Group, who represents public companies, among other things, in all aspects of the proxy season. With me on the webcast today is Josh Agan, a senior counsel at Foley, who specializes in executive compensation and related disclosures. Richard Grubaugh, senior vice president at the proxy solicitation firm of D.F. King & Company. And last but certainly not least, Patrick McGurn, special counsel for institutional investor services. I'm going to quickly go through the agenda here. We have a lot to cover. We'll move fast. If you have questions, please feel to submit them electronically. If time permits, we'll answer them during the presentation. Otherwise, we'll certainly follow up afterwards. We'll start off with a brief discussion on D&O questionnaires, then move to SEC rulemaking updates. We'll then cover voting policy changes from both ISS and Glass Lewis, talk a little bit about shareholder proposals, then in particular, in more detail, proxy access, followed by say on pay and compensation governance trends and shareholder engagement. Briefly, the question people always ask at the start of the proxy season: what do I need to change in my D&O questionnaires? The good news, no updates this year for SEC or stock exchange rule changes. However, companies will need to consider what they are going to do, if anything, with respect to the PCAOB's auditing standard number 18 regarding related party transactions that will now be effective. And I know from personal experience, a lot of companies are wrestling with this. Certainly you'll want to discuss with your auditors what to do about this, and have seen varying responses there. But where some companies are coming out on this is, in addition to the standard question to directors and officers whether they or their immediately family members have had any related party transactions, some companies are now going to be asking the directors and officers to identify by name those immediate family members, perhaps where they work and what positions they have there, as well as entities they control. And if you're going to go down that route, it's important to keep in mind it will be a good amount of work, especially this first year. People can have a lot of immediate family members. Someone who's a director, who's a CEO, for example, could have many entities below them that they control or have significant influence over. Furthermore, once you collect all that data, you'll need to think about what are you going to do with it. I was on the phone with a client yesterday who was explaining to me they have 25 different ERP systems that they would need to run that data through to see if there's been any related party transactions or not. So something definitely to give some thought to as to how you're going to handle that. I will then turn it over to Josh to talk about SEC rulemaking update.
Thanks, John. So we'd like to spend just a few minutes getting up to speed on the SEC's rulemaking activity in 2015. There were 4 major actions implementing Dodd-Frank mandates in the year. The first and the only one of these that's final is the CEO pay ratio disclosure rules were finalized. And then there were 3 other rules that were proposed but have not yet been finalized. The rule that would require mandatory clawbacks of compensation, the rules that would require pay for performance disclosure in the proxy statements, and then rules that would require disclosure of anti-hedging policies in the proxy statement. The headline for purposes of today's topic is that none of these rule changes are effective for the 2016 proxy season. If you take away only one thing from this SEC update, it's that. And we've got a lot to get through today, so we're not going to spend a lot of time on these, but these slides do contain some more detailed information, but for now we're just going to do a real quick overview so that we kind of get the big picture. So first, the CEO pay ratio rules were finalized in August, but they have a delayed effective date, so they're not going to be effective until 2017. Compensation paid in 2017 will need to be disclosed, and so that'll appear for all calendar year companies in their 2018 proxy statements. So we have a couple of years. The required disclosure is going to consist of 3 elements: the median of the annual total compensation of all employees of the company and its consolidated subsidiaries other than the CEO. The second element will just be the CEO's compensation, and then the third element is the ratio of those 2 numbers. The only part of this is going to be a little challenging for people with identifying the median employee because the pool is going to include all full-time, part-time, seasonal, temporary workers employed on a single day selected by the company, and it'll include international employees as well as U.S. employees. The day selected by the company to identify the median employee can be any day in the last 3 months of the year. Companies can use either the entire employee population and look at everyone's compensation, or they can use statistical sampling to identify the median employee, or they can use other reasonable methods. And as far as the compensation measure that they're going to use to identify the median employee, you can use either the kind of summary compensation table, total compensation number for everybody, or you can use a substitute like tax reporting like W-2 compensation or annual cash compensation, because it may be difficult to calculate that summary compensation table number for all your employees. But then once you identify the median employee for purposes of the disclosure, you'll have to calculate their actual summary compensation table compensation. You only have to identify the median employee once every 3 years unless there's some significant change. So I guess the action steps for now are probably just get your working group together, evaluate what kind of compensation measures you might use, whether it's W-2 or annual cash compensation, whether you're going to need to use statistical sampling. I think most multinationals are concluding they probably will need to use statistical sampling just because their systems, their payroll systems don't necessarily collect the same information for all their international employees as they do for the domestic employees. And so then, how are you going to be able to identify the median employee without using statistical sampling? So the third step is prepare a mock-up disclosure, using either 2014 or 15 compensation to see what the ratio is likely to be. I think a lot of our clients are finding their boards are interested in at least getting kind of a ballpark sense of what the ratio is likely to be even at this stage. The first of the proposed rules I'd like to talk about are the clawback rules. So these are not final, they're not effective yet. The way they'd work is that stock exchanges would adopt rules requiring listed companies to adopt compensation recovery policies. The policies would need to be triggered by an accounting restatement that's required to correct an error that is material to previously issued financial statements. It would apply to incentive-based compensation is the term used that's received by executives in the 3 fiscal years preceding the date on which they're required to prepare the accounting restatement. I guess the headline about incentive-based compensation is going to include compensation that's payable based on a goal relating to stock price or TSR, but it would not cover stock options that are granted, earned, and vested based solely on continued employment. So time vesting options generally are not going to be subject to the clawbacks, which is a bit of a surprise to some people. The amount of the recovery is going to be the excess of the amount actually received over the amount that should have been received based on the restated numbers. It's a no-fault basis for recovery. Doesn't matter, unlike under Sarbanes-Oxley, doesn't matter if the executive was at fault or involved in the financials that were restated. The one thing that we should do now, even though the rules are only proposed, is ensure that awards we're making now that we think are going to be subject to the eventual clawback rules have a provision that allows the company to contractually claw back amounts that it's required to do so. Because the way that these rules will become effective, they may have a little bit of retroactive application. They might cover awards that are being granted now, even before the rules are effective. Real briefly on the other proposed rules that pay for performance disclosure rules, again, they're not effective yet. The disclosure is going to consist of 2 elements. There's going to be this required table under the proposed rules, which shows the compensation actually paid and the TSR of the company and its selected peer group. Then you have to do a graph or narrative providing a clear description of the relationship between the compensation actually paid and the stock performance. The final proposed rules relate to hedging disclosure. Again, these are not effective yet. And there was a little bit of concern when the proposed rules came out that it could cover sort of routine diversification transactions that people wouldn't want to prohibit. So the SEC has signaled that it's considering making some changes in the final rules to address that concern. But the required disclosure is basically just going to be about the company's anti-hedging policies. And the only things to maybe note here are, a lot of companies already have anti-hedging policies, but they'll need to look at how their existing policies match up against the required disclosure to see if you can just, say flatly that you don't permit hedging or, whatever the case may be, or if you want to make some tweaks to your existing policies so the language matches up. And then the disclosure is going to apply to all employees, whereas a lot of hedging policies currently only cover executives, so companies will have to decide if they want to broaden that. And with that, I will hand things over to Pat for a discussion of the ISS policy updates for 2016.
Great. Thanks a lot, Josh, and welcome to everybody on the call today. I think not a huge number of changes coming from ISS under our benchmark policy for 2016, and obviously we released these policy updates a couple weeks ago. I think I just want to remind folks that we'll be putting out some FAQs, hopefully before the end of the year. I think it'll provide some additional details on how we'll be applying these new policies as well as interpreting some of our existing policies where the facts and circumstances may have changed. I think probably the change that's drawn the most attention but won't have a huge impact in 2016 relates to overboarding. I think this is actually an issue that ISS addressed in a number of different markets this year, including the U.S., Canada, the United Kingdom, and also Australia. I think it seems to be a very top-of-mind issue for institutional investors these days, who I think sometimes worry that directors faced with all the new regulatory and workload requirements, I think are sometimes overextending themselves. I think for non-CEO directors, the new policy is to recommend against directors who sit on more than 5 public company boards, and that's down from 6, which has been the standards that's applied for more than a decade now under the ISS benchmark policy. I think We're going to note serving on more than 5 boards as a concern in 2016, but we're actually going to have a 1-year grace period, I think, so we won't see negative recommendations being triggered until 2017, and that'll allow both boards and individual directors to sort of rearrange their dance cards to make sure that this does not lead to any problems. Notably, a lot of times when we are changing policy like this, we will provide some additional time for board members to make decisions regarding, boards they want to step down from, or individual companies to go out and recruit new directors, so there'll be no disruptions in board membership at those firms. We had gone out for comment talking about a potential change as it relates to CEO directors, but we've decided for now at least to make no change to the current policy, and that is recommending against sitting CEOs who sit on more than 2 public company boards besides their own home board. I think that's an issue we're going to continue to look at over the course of the next couple of months, I think, and into next year. I think one issue that we're looking for feedback on, for example, is how to deal with sitting CEOs who serve on subsidiary boards and sort of where to draw the line in that regard. Obviously, we don't want to face a situation where our policy does not allow CEOs to serve on any outside boards, I think, and so we're going to take some additional time to look at and discuss with various constituents how we can address that issue going forward. I think switching gears a little bit, another policy change, I think, relates to unilateral bylaw and charter amendments being made by boards of directors. Unfortunately, from a shareholder perspective at least, this is a trend that has been rising in recent years. I think we've seen waves over the last couple of years of boards unilaterally adopting, for example, fee-shifting bylaws or bylaws related to so-called golden leash arrangements without putting those material changes in shareholder rights up for votes. The tweak that we're making to that policy for this season is that we're going to go from just dinging the board at the next annual meeting to potentially carrying those negative recommendations along to subsequent meetings until boards actually restore the right, or at least allow shareholders an up or down vote on the change in those governing documents. Notably, in our annual policy survey, nearly 60% of our institutional investor clients who responded to the survey, I think, indicated that that was a position that they would favor, is that keeping the directors literally in the penalty box until that right is restored. I think there are a couple of unilateral amendments classifying the board and establishing supermajority vote requirements that are likely to draw a sort of automatic continuing negative recommendations against boards. It'll generally be a case-by-case process that we'll look at in those situations. We bifurcated our approach as well to split off newly public companies that we've seen in recent years, companies coming to market with very shareholder unfriendly governance provisions in place, sometimes adopting these provisions literally on the eve of their actual IPO transactions, sometimes even after they'd gone out with all their issuing documents. I think going forward, what we're going to do is again, adopt a case-by-case approach there that will really determine for how long we will make recommendations against boards that come to market with shareholder unfriendly features in place. The same 2 major issues, classification of the board and supermajority vote requirements, since they tend to bind investors over a longer period of time, will be something that we'll take an especially close look at. I think notably, we'll make case-by-case determinations on directors post-IPO unless the change is reversed or they allow shareholders the opportunity to ratify those changes. Notably, we have seen some companies recently putting sunset provisions in their bylaws or charters that indicate that after a number of years, some of those provisions will go away, I think, when they're no longer necessary. I think proxy access nominees, I think on the next slide, I think we're continuing to evaluate contested meetings under the same formula that we've always used, but we did want to make note that there were some tweaks, some differences between how we may see proxy access nominees candidacies playing out versus the criterion that we will see in traditional kind of two-slate proxy fights. I think, and so we just added some additional guidance out in the marketplace for 2016 and beyond regarding some of the additional factors that we'll be taking a look at in those situations. And notably, they go to sort of both the nominees and the nominator, I think, and so you can go to our website to look at those updates for more information if you wanted, I think. And then finally, just a host of some other smaller changes. If you are a company, especially a REIT that has an externally managed issuer structure, be aware that going forward, providing negligible or no disclosure about compensation practices will likely draw a negative recommendation. We set forth the rationale and the details in that policy on our website at issgovernance.com. I think shareholder proposals seeking executive equity retention programs, again, just some tweaks and clarifications to our policy on that issue. And there's also some sort of catch-up amendments that we made regarding some shareholder proposals on various environmental and social issues. But that pretty much wraps up the major changes for next year from ISS's perspective, at least.
Thanks, Pat. And this is Josh, and we'll continue on with Glass Lewis briefly. Glass Lewis also is lowering its overboarding threshold from 6 directors down to 5 for non-CEO directors. For executive officers, it's bringing its overboarding threshold into line with ISS, and now the number will be 2 rather than 3. They also have a transition period for the first year. They've provided some additional guidance on when you have conflicting management and shareholder proposals, how they're going to decide how to recommend. And they changed their policy a little bit on exclusive forum provisions for pre-IPO adoptions. It's no longer going to trigger an automatic negative vote recommendation for the governance committee chair. There'll be some other factors that are considered. They also modified their consideration of the nominating committee role and board composition and their policies on environmental and social risk oversight. The compensation policies, just some minor changes. They highlighted some factors they'll consider when they're analyzing one-time and transitional awards. They also are emphasizing they want clear disclosure for significant compensation changes. So I think that's all for the updates. Rick, just wanted to ask you, what is your take on the ISS and Glass Lewis updates this year? Anything surprising or noteworthy from your perspective?
No, from our angle, there's nothing overly shocking. I mean, the overboarding policy changes from both ISS and Glass Lewis, although extremely significant, this has been the focus of some of the major institutional investors for a while. So BlackRock notably only wants to see 4 total board seats. So I think from that standpoint, most companies, directors are well aware that this was going to be a focus in the future. So I don't think anybody was caught off guard tremendously. And the only other thing I would add is, one of the things that Glass Lewis, many companies don't realize that there is an engagement process with Glass Lewis now, that they have a portal that can reach out and have some level of engagement with the Glass Lewis analysts.
Okay, thanks. Yeah, that's helpful. John, I will hand it back over to you for discussion of shareholder proposals.
Thanks, Josh. The slide we're looking at here illustrates the top proposals for 2015. As a general matter, we expect to see similar proposals in 2016. Expect political and lobbying activities, proxy access, which we'll talk about in more detail, independent chair proposals to be key this year, as was last year. Also will continue to be a large number of social proposals, such as those on anti-discrimination and environmental proposals on greenhouse gas and sustainability reporting, as well as in the compensation area relating to compensation equity vesting that occurs upon change of control. And certainly for smaller companies that haven't adopted majority vote or don't have a right to call a special meeting or still have a staggered board, for those types of companies, those will continue to be top proposals. Turning to the next slide here on proposals submitted to a vote, a number of these types of proposals, if you get one, you can often settle. Those on political and lobbying activities or the social and environmental proposals, and you can see a lot of those don't always go to a vote. Kind of on the other end of the spectrum is those that I would say go to the governance structure, such as supermajority voting, declassifying the board, majority vote, calling a special meeting. Those tend to get the highest votes, and if you get that type of proposal, I think you need to think about whether that is worth fighting, or oftentimes you can go to the proponent and settle by adopting it a year later if you know you're ultimately going to be defeated on it if you put it up. I would note that we have an appendix to this slide deck that contains a lot more details on a number of these proposals, which we won't take time to go through here today, but it's there for your reference. So I'd like to ask Rick, other than proxy access, which we'll talk about in a lot more detail, what are you seeing as other big expected shareholder proposals for 2016? Is there anything new on that front?
Yeah. Well, first, since here we have to assume we will see a wave of political contributions, just like we have in the past. A couple new proposals that we're seeing that are rather odd, and whether or not they would withstand a no action request, we don't know. One is to adopt a payout policy to give preference to stock repurchases rather than dividends. A number of companies have gotten this proposal. I don't know whether anyone has submitted no action requests yet. An auditor rotation is coming back. As many know, Carpenters a number of years ago tried a focus on auditor rotation. There is a new proposal floating around that is requesting for audit committees to go out for an RFP for their auditor relationship every 8 years. So it's a different twist on that. So too early to tell whether that will get any traction.
Okay, and Pat, anything from your perspective on proposals generally?
No, actually, we're expecting a lot of things sort of driven in line with the political campaign that's playing out right now. Buybacks have been an issue out on the campaign trail, and we've actually seen some draft proposals, both pro and as the pro ones you mentioned before, but there's also some anti-buyback proposals we're expecting to see as well, and it'll be interesting to see whether that passes the test of being a matter of political debate at the SEC or gets kicked out as ordinary business. I think, and a slew of smaller proposals related to the environment. I think those were inevitable as well. In light of all the broader discussions about climate change and risks that are out there today, I think. But by and large, I think it's going to be a case of 2015 on steroids, if you would. A lot of the same proposals showing up in very significant numbers, especially access for next season.
Thanks, Pat. Turning then, if you get a proposal, companies always want to try to exclude them. But certainly developments here over the last year has made the ability to do so greatly reduced. In particular, you'll want to pay attention to the SEC staff legal bulletin that came out in October of 2015 that provides interpretive guidance on two provisions of Rule 14A8. As a little background on the first one, 14A8 I-9, the exclusion relating to conflicting proposals. As you may recall, in 2015, Whole Foods attempted to exclude a proxy access proposal on the basis it conflicted with a management proposal. SEC issued a no-action letter allowing that. There was then a lot of concern in the investor community. SEC reversed and for a while stopped expressing views on that pending a review. The outcome of that review is this staff legal bulletin. And the bottom line here is it will now be rare to be able to exclude on a conflicting proposal basis. Only if no reasonable shareholder could vote for both would you be able to exclude. And I think it's important to point out here, this is not just relevant for proxy access, even though that may be on everyone's minds. Certainly over the years, this has been used to exclude competing proposal, for example, on the threshold for right to call a special meeting, been used to exclude equity vesting type proposals if the company would have its own proposal up on an equity plan. So there's a number of areas that this comes into play. In that staff legal bulletin, the SEC also confirmed it would continue to follow its traditional approach on the exclusion relating to ordinary business operations, despite a recent Third Circuit case that was perhaps suggesting otherwise. Let's turn then to what a lot of people are interested in, proxy access. Certainly gained momentum in 2015. This slide shows that there was a big spike both in the number of proposals as well as the votes received. Number of proposals due to the New York City Comptroller project. And part of the reason for the votes increasing is they had come out with a standard proposal with two of the primary elements for proxy access, that shareholders need to hold at least 3% of the shares for 3 years to be eligible for proxy access, and that proposal has gained significant more votes than in prior years. The next slide here shows proposals when there's not a competing shareholder proposal on the ballot, how those fared. I think the bar at the bottom is important as well. 7 board-sponsored proposals last year when there was also a competing shareholder proposal. Those had mixed results. 3 were successful. And I think it's a small sample. I think the real takeaway from those is they are highly dependent on what your shareholder base is. Turning to some more trends on proxy access, as we enter the 2016 proxy season, over 100 companies have adopted proxy access bylaws. At least half of those are at companies where shareholders had not approved a proxy access shareholder proposal. Some were certainly settlements and the like in response to the New York City proposals last year. There's a further at least 30 more companies that have not yet adopted proxy access but will be, either because shareholders approved a proposal or a management proposal was approved, or the company's announced its intention to do so unilaterally. Certainly the 3% minimum ownership and 3-year minimum holding period are becoming fairly standard, both for a shareholder proposal, but as well as for what companies are adopting. There's some variation on the percentage ownership with a few companies that have been successful at 5%, but that is really, again, due to unique shareholder bases there where there are significant shareholders that might be in favor of that. 2 other areas that have gained a lot of attention is the cap on the number of nominees. Most of the proposals last year were at 25% of the board. As companies have adopted them, most have been at 20%. Proposals that are out this year are doing it the alternative 25%, or at least 2 directors. And as we've seen companies adopting proxy access bylaws this year, they've been increasingly going 20% with at least 2. Another area here is the number of shareholders in a group that may aggregate holdings. Most companies have been adopting with a limit on that at 20. Proposals last year didn't get into that. Proposals this year are saying that number should be unrestricted, which takes us to the slide we have up here on the proposals that Messrs. McRitchie and Shevden have been submitting for 2016 meetings. They are more restrictive than the 2015 New York City Comptroller proposals. In particular, they address recallable loaned stock, that should count towards the ownership requirement. As I noted, unrestricted number of shareholders may form a group. They're adding the minimum of 2 directors. And the other twist is that those bylaws may not contain restrictions on nominations or renominations that don't apply to other directors. I would also note that there's a few companies who adopted proxy access in 2015 who are receiving proposals as well, wanting to change what was in their bylaws. If you receive a proxy access bylaw proposal, number of alternatives, each have their pros and cons. First, to negotiate withdrawal in exchange for a commitment to adopt. That is only going to be possible if you are going to accept all the terms in the proposal. Second, to include the proposal and recommend against it. That is not likely to be successful given the outcome of votes last year, unless you have a fairly unique shareholder base that would defeat that. In particular, ISS will certainly recommend in favor of any of the standard proposals that are out there. And if you get a majority vote on that type of proposal, then you'll have to think about implementing it the next year. One thing that worked last year for GE was to adopt a proxy access bylaw and seek to exclude it as substantially implemented. They followed the proposal last year, but then had a few twists in it, and were able to exclude the proposal. I think that will be more difficult this year because of the more restrictive proposals that are out there from Shevden and others. You would really need to follow all the terms in the proposal to be able to try to do this. What we are seeing at some companies is that they are adopting proxy access bylaws and then using that to recommend against the shareholder proposal as unnecessary. It helps show the company's commitment to proxy access and can be somewhat effective if there are some terms other than the key ones that you want to implement on your terms. Although there's always the question of, how far can one go with deviating from the proxy access proposal terms. Another alternative that companies did last year and some are considering this year is to put up a competing proposal. So you wouldn't have all the details of a bylaw, but have the shareholders vote and then adopt a bylaw at the end of that process. Key in all this here is shareholder engagement, especially if you're going to do something different than the shareholder proposal. Want to make sure that you are out there and talking with your shareholders and finding out what they're interested in. In addition to the key terms that we've talked about, there are a number of other terms that I've listed here on this slide that we won't take time to get into detail, but you want to consider these. These are all important to investors, and certain investors may vote based on how these terms come out. At this point, what I'd like to do is ask Pat McGurn, what flexibility does a board have in implementing proxy access? For example, if there's been a majority vote in favor of one of these proposals, or if a company has a proposal right now and is looking at, doing 3%, 3 years, following that, but perhaps limits its nominees to the greater of 20% or 2 instead of 25%, or puts a cap on the number of shareholders in a group at 20, will those types of deviations be seen as responsive?
I think that's going to be the big issue this season, is for companies that had majority votes last year, or for boards that just simply preempted proposals by putting their own bylaws in place, whether shareholders view those actions as being responsive to the votes that occurred in the past, and that they're accountable to shareholders in the design of the ones that they adopted unilaterally, I think. And so I think it will be a case-by-case determination for most investors at companies that have adopted this based upon the actual provisions in each bylaw that is in play, I think. And I really don't, it's hard to really estimate how this debate's going to turn out. I think will investors sort of go along with a 3-3-2020 as you've outlined it? How much attention is going to be paid to some of the fine print provisions, the ones that were on your last slide? I think I know we've already seen some companies going out and in some instances actually on multiple occasions amending their existing bylaws based upon serial feedback that they're receiving from institutional investors as they engage in the run-up to proxy season. I would guess that process may continue right up until the time of annual meetings at many firms, I think. And so over the long run, you might see sort of private ordering in terms of at least engagement and actions by boards taking care of this problem, rather than seeing it occur in terms of significant no-vote campaigns against board members. But it is going to be a challenge this year for boards, because ultimately I think a lot of boards thought they had dismissed this issue by adopting a bylaw, and they may discover to their consternation that that's simply not the case, that there may be some sort of killer features in it that are going to attract some opposition this year.
Thanks, Pat. And Rick, if a company has a proposal, and as we're seeing in a lot of companies, boards are willing to consider potentially adopting proxy access, but, don't want to follow exactly, especially all the new generation proposals to a T. What do you see as kind of the most effective alternative to doing so? Do you vote on both a board competing proposal and a shareholder proposal, or would you be better off adopting your own proxy access bylaw with the terms you want and then arguing that the proposal from the shareholder should be defeated because you've already implemented it, and at least on some of the key items like 3% in 3 years followed that?
Yeah. What we're seeing, it's obviously a change now that Chevedden is one of the main proponents here, and as he's legendary for not being willing to engage with issuers and to find common ground and then to withdraw his proposal. So many of these proposals are going to go to a vote regardless. So what we're going to see many companies doing is adopting, and most are adopting 3-3. They do have unique shareholder base. And then I believe we're going to see 20 with a minimum of 2, and many are looking at implementing 20 as the aggregation. But the key is going to be in the proxy disclosure. It's going to be critical for the companies to disclose the engagement that they've had with their shareholders, and that the features that they've adopted are acceptable and in light of the engagement acceptable and to the main holders, which many of the main institutional investors are okay with these features. Not all by any means, but you certainly can get some form of consensus. So I believe it's going to be the key features is going to be the disclosure that companies have had.
Thanks, Rick. Yeah, because I think it's important to remember that even if you go ahead and unilaterally adopt a proxy access bylaw, that certainly does not insulate you from a proxy access proposal next year on specific terms in that proxy access bylaw, as we've certainly seen this year. McRitchie publicized the proposal that he has given Whole Foods to change the terms of their bylaws. So that disclosing the engagement with shareholders and going out and doing that, important not just for getting the vote, but for demonstrating that you've done that to other shareholders. Haley, time for the CLE question.
Yep. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question on the screen after it is announced and press the Submit button. The code is I06QN. Again, that is the letter I as in India, the number 0, the number 6, the letter Q as in Quebec, the letter N as in November. I06QN. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. At this time, the poll is now closed. I would like to return the program to our speakers.
Thanks. And with that, I'll turn it over to Josh to talk about Say on Pay.
Thanks, John. So Say on Pay, our perennial favorite topic on this webinar. The overall results in 2015 were very similar to preceding years, although of course the results for individual companies varied. The average support was north of 90% again. Only about 2% of companies received less than majority support. The proportion of programs receiving less than 70%, which is the level that draws additional scrutiny from ISS, fell slightly, but only slightly from 2014. Shareholder engagement appeared to work for companies that had failed votes in 2014 because a substantial number of those received a big turnaround and got more than 80% support in 2015. On the other hand, of the 49 companies that through the end of June had lost their Say on Pay votes in 2015, a substantial number of them had received over 80% approval in 2014. So again, past performance is no guarantee of future results when it comes to Say on Pay. The most common reasons for failed Say on Pay votes are, again, probably nothing too new. There's a pay and performance disconnect. The stock price has not been performing to shareholder satisfaction, insufficiently rigorous performance goals. If there were special large awards or a large chunk of equity that's not tied to performance goals, that can sometimes be tied to failed Say on Pay. And then, of course, the problematic pay practices, things like excessive severance, tax gross-ups, excessive perquisites, can also lead to or contribute to a failed Say on Pay vote. Disclosure trends, I mean, we continue to see kind of the old news ones like the executive summaries to just kind of summarize everything up front. But also I think the newer ones maybe are shareholder engagement, more and more attention devoted to that, particularly at companies that have had a less than satisfactory Say on Pay vote the preceding year. You'll get quite a bit of detail about the percentage of shareholders that, or percentage of shares represented by the shareholders that management went out and talked to, whether the board was involved, all of those types of disclosure about engagement, and then of course the resulting changes that from that engagement, if any, that the company made to respond to the poor Say on Pay votes. And then pay and performance relationship, people continue to show that in various ways using graphs, realizable pay disclosures, those sorts of things. So the forecast for Say on Pay in 2016, I guess maybe the most significant factor that might be different is if the stock market hasn't been great, flat and declining stock prices may cause performance awards to fall short of target, and that can create some pressure if retention is a concern for the comp committee to waive performance goals or make some sort of special retention awards and that sort of thing. But I think, as always, that's going to be seen as potentially problematic unless you've got a very convincing reason for doing it. The presidential election cycle will be going on. There's going to be potentially media focus on executive pay with tying to the themes of income inequality and the shrinking middle class. So there might be more just media attention on it. There weren't any significant changes in proxy advisor policies relating to say on pay, so that's probably not going to be much of a factor, but or much of a difference from preceding years. Next year, in 2017, is going to be the year that companies are required to have that second say when on pay vote, where they seek shareholder input on how often to have say on pay, whether it's annually, biennially, or triennially. And but you could conceivably see some companies doing that early this year. So just turning to Pat. Pat, what are your predictions for how management say on pay is going to fare in 2016?
Yeah, the engagements we've had with the corporate board members recently a lot of them have centered on compensation. I think that a lot of boards have come to the realization, and the comp committees have decided to get out in front of these issues. They know that their stock price and their TSR was probably down for the year overall, but the relationship with what's the reported pay in the proxy statement may create some disconnects in terms of pay for performance. And so we're expecting a lot of engagement, a lot of communications, a lot of ancillary disclosures other than the standard tables in proxy statements this year by boards as they try and tell their story. And I think that's the goal that's out there, is to use engagement to explain to shareholders how their pay was matched with performance rather than the delinkage between the two. But some boards, frankly, may have a challenging case to make in this instance, especially as you noted earlier, if they've done anything to sort of make whole those senior executives if they had failed to reach what had been some lofty performance goals that were put in place in the past. I think so. It's going to be an interesting year. This is really the first year when say on pay has been a mandated issue following Dodd-Frank's passage, where the market was either flat or down for most companies, I think, and so it is going to require a lot more in terms of engagement opportunities with institutional investors. And luckily, it's not one of those huge years like you mentioned that 2017 will be, when the frequency issue comes back and all the original triennials show up on the ballot. So it could be that boards that get out there early are going to get an audience and can make their case to investors.
Thanks. Just turning now to Rick. So for companies that have had successful say-on-pay votes in the past, but they're concerned going into 2016 because of those disappointing financial results and stock price performance that Pat alluded to, what advice would you give on steps to take that companies can take to maximize their chances of avoiding a failed say-on-pay vote?
Oh, certainly, yeah. Well, first, past results on say on pay should never let your guard down. It's really, every company should be ready for a negative say on pay recommendations from advisory firms as well as some of their institutional investors, and be prepared. Successful companies, during a say-on-pay solicitation effort, it's an all-hands-on-deck event, and it should be a 12-month-a-year event. They should be preparing for pushback and have all of their bullet points and their arguments already outlined. And it shouldn't be when either ISS or Glass Lewis recommends against say-on-pay. They should be armed, ready to go, have all of their arguments, their pay-for-performance connections ready to go, as much as possible in their proxy disclosure. But that said, that's many times that's not enough. There needs to be either a supplemental filing or some type of a talking point, a document put together by the company in order to really hammer home with the institutional investors and in face of a negative recommendations from the proxy advisory firms to vote in favor of them.
Thanks for that perspective. I guess just shifting gears slightly, wanted to cover one more issue that's been developing in 2015 that could be relevant for 2016, particularly if you have, if you're putting up an equity incentive plan for shareholder approval this year. There has been some shareholder litigation over director pay. There in past years, now getting to be distant past years, there was maybe more litigation over executive pay, but there has been a little bit in relating to director pay, and there was one potentially significant development in 2015 in this area, the Citrix case, where the Delaware court refused to dismiss a breach of fiduciary duty claim brought by shareholders arising from equity compensation awards that Citrix had granted to its non-employee directors. The grants were made under Citrix's general omnibus equity incentive plan that covered both awards for employees as well as directors. And that plan included individual award limits. And typically in the past, I think at least some companies have thought they could rely on that shareholder approval to get business judgment rule deference on the amount of compensation that they're awarding. Because shareholders have approved those individual limits. As long as they stay under those individual limits, then the shareholders have essentially blessed what the board is doing. This court rejected that argument, saying that the limits in the plan were not meaningful because they were too high. In theory, I think the individual award limit in this plan would have authorized up to something like $50 million in value based on Citrix's stock price and the number of shares authorized under that individual award limit. And so the court said, no, you don't get business judgment rule deference. Instead, you're going to have to show that your compensation is entirely fair. There have been a couple other cases similar to this Facebook litigation where they were the company's defense has been that Mark Zuckerberg was the controlling shareholder. He sat in the board meetings where they approved the amount of compensation awarded to directors, and therefore, even though it wasn't a formal shareholder approval, it was sufficient. I'm not sure that argument's going to fly, but that's kind of an unusual case anyway. But there was a more similar case in 2012, this Seinfeld versus Slaughter, where, again, the court didn't grant business judgment rule deference to director compensation. So the recommendation that could come up in 2016 is if you're putting up your equity plan for shareholder approval because you need to increase the number of shares or for whatever other reason, 162M, you might want to add separate meaningful award limits on awards to individual non-employee directors, or even establishing a separate director plan that you can get shareholder approval for so that you'll have that shareholder approval of those specific limits for the directors. I'll turn it back over to John.
Thanks, Josh. I think we'll wrap it up here with just a few brief remarks on shareholder engagement. We've covered this a bit in the proxy access and say and pay sections. In my view, three key takeaways on shareholder engagement. One, do it early, do it often. If the first time you're talking to your shareholders is when you have a critical vote and need to get it, that will make it a lot more difficult. And getting their feedback early on can help you better have a good strategy to deal with whatever the issue may be at stake, and make it more likely that your shareholders will buy in and vote the direction that you ultimately want to go. Second, disclose. Most companies do some form of shareholder engagement, but I think it's only very recently become a trend to disclose what companies are doing in the proxy statement. Certainly last year, we saw a number of companies moving to having sections in their proxy statement discussing what they do, and certainly with companies receiving, at least large companies, the Vanguard letter in February of this year regarding shareholder engagement, expect to see more companies doing that. And the last thing is to think about, who is doing your shareholder engagement. It's not as simple as it used to be with the CFO talking to the portfolio manager. There's the governance side of the shareholders, depending on the issue. shareholders may want, or you may want, directors involved. For example, certainly if you've had a failed say on pay vote, shareholders are going to expect to be talking with compensation committee members. So with that, we are out of time here. If you have questions, please feel free to submit them by email, and we'll respond on the system here. And thank you all for attending. I hope you found this useful as you prepare for your upcoming proxy season. And I'll turn it back over to Haley.
Like John said, we invite you to contact any of today's speakers. So if you have additional questions or would just like more information on their particular topics. And this wraps up our web conference today. So as a reminder, today's program is being recorded and will be available on Foley's website in the next few days. At the conclusion of this program, a questionnaire will appear. Please take a minute or two to give us your feedback about the presentation today. It's important to us to know your thoughts and helps us shape our programs going forward. If you have any questions regarding CLE credit for this program, please contact Haley Musgrave at hmusgrave@foley.com. As a reminder, CLE processing takes approximately 8 weeks. Eligible participants will receive their certificates of attendance via email at that time. Thank you again for your participation.